This is Conversations in Civics. I'm Dr. Terry Susan Fine. Joining me now is John Watson, the Social Studies Subject Area Leader at Mulrennan Middle School. This conversation will revolve around the levels, functions, and powers of the courts at the state and federal levels as established in the Constitution. John, I'm sure you've got lots of questions.
Yes.
What's your first one?
All right, thank you. Actually, my first question is, the framers of the Constitution made sure to create vagueness within their description of the judicial branch. Why did they do that? Why did they make it so vague with their description?
You know, it's interesting. Sometimes when I'm in class, I'll say to my students, you know, whenever you're working on a group project, there's always that one group member that doesn't do their homework. The third article of the Constitution looks like that to me, right? It's so vague, and it looks like somebody was just really lazy and didn't do their work. Because if you look at the first and the second article of the Constitution and compare it to the third, what do you find? Article 1, 2 senators per state, 1 member of the U.S. House of Representatives per district, 2-year terms for members of the House, 6-year terms for senators, right? We look at Article 2, there shall be 1 president, 4-year term. Now, it's not vague, right? We know specifically how many members of Congress there are going to be, at least at the time, and then of course it's grown as the nation has grown, how many presidents there are going to be, right? If we even look back at, you know, the election of 2000, right, we said, well, let's just give it to both of them, right? You know, there's 2 people want to be president, the split's too close to call, we don't do that. Right. Very specific, 1 president. But then we get to Article 3, and all it says is that there shall be 1 Supreme Court and all other courts that Congress shall create. Even that 1 Supreme Court, which has 9 members, only has 9 members based on tradition, right, not based on any requirement. So we now have, in the 20th century, we've now sort of established that 9-member court, and that's because, of course, Franklin Roosevelt tried for there to be a 15-member court, and that didn't quite run. So we now have 9 members to the court, but even if a member of the court resigns or unfortunately dies or recuses him or herself from a case, we've certainly seen some very important cases being made with 7 people voting, 8 people voting. So it's certainly not a requirement, except sort of in the 20th century, that we've seen the requirement of 9. We also see vagueness is that there are no qualifications, right? You have to be a natural-born citizen to be President of the United States. It doesn't say you have to be an attorney. I mean, of course, to be an officer of the United States serving the public, you need to be a U.S. citizen, whether naturalized or native-born. So sometimes I say to my students, I'll say, well, what qualifies anybody to be a Supreme Court justice? They say, well, we don't know. And I said, well, you have to be breathing, right? You have to be breathing, because other than that, we assume that these folks are going to be judges, but they're not. Right. We assume that these folks are going to be lawyers, but they don't have to be. Right. And so there's a lot of vagueness. In fact, what a lot of people don't realize, that of all the justices who've been Chief Justice of the U.S. Supreme Court, 2/3 of them were not members of the Supreme Court when they were nominated to be Chief Justice. Right. So it's actually more common to be an outsider becoming Chief Justice than to be an insider. If we look over since 1789, since the first Supreme Court was actually seated, we see that of all those who have ever served as a judge and all those who haven't, if we were to combine all their years of experience together and divide it by the number, taking the average, we would see that the number of years of experience as a judge over time is 1.5 years. Wow. So you don't need experience, you don't need an education, you don't need to be, I guess you have to be old enough to vote, right? You're voting on cases, so you better be old enough to vote. But other than that, there's no set number of judges. It's almost like the person who didn't do their work on the group project.
Right. And it's left open. So here's the thing, with this vagueness, has that worked out to our advantage or disadvantage as a country when it comes to this vagueness?
Well, it certainly has turned out, in my belief, to an advantage, because certainly as the population has grown, I think that the technicalities of the laws have grown. The demands on government, as more citizens get involved in politics, there are more demands on government to write laws, and the more laws that are written, the more laws that need to be interpreted at some point.
Right.
And so certainly that's given the Congress the flexibility of creating the lower district courts. It's given Congress the flexibility of creating circuit courts and creating circuits and creating more circuits if they want, and that way there are more judges involved and more courts involved because of the number of cases and demands. At the same time, what's also done is also given the states a role, and the states playing a role in sort of setting up their own court systems as well.
And that makes perfect sense too, allowing for the growth and everything. This is a growing nation and so forth. And with the states, what I noticed about states' governments and their judges, their judicial systems, many judicial systems within a state, these judges are running for office. They're actually partisans running for a particular office. Do you find that by them doing that, that they're still able to adjudicate fairly and make fair decisions about laws?
That's a great question. We often assume that because something is partisan, that it's biased in a way that precludes objectivity, right? Now, it's up to each state whether or not they want to have elections or appointments for judges, and whether they want elections to have party labels next to them or not. Okay, those decisions are made at the state level. However, even in making those decisions at the state level, it's very important to realize that any decision made at the state level can be appealed up to the United States Supreme Court. So judges still have to abide by certain guidelines. Even in Florida, for example, there are different amounts that people have to pay when they file to run for office. So by making something an elected judgeship, the state actually makes money because that person has to pay money to file their intent to run for office. But if they're only appointed offices, then there are no elections, right? So money actually comes to the state the more elections you have. And if they're partisan races versus nonpartisan, no matter if it's judge or in an executive or legislative position, there's actually more money tied to those as well.
Okay, so now we see the money coming in, and that plays a role. With that being said, do you see any structural issues, the way that states set up their judicial branches, that might actually lend itself to work against justice? Do you see any structural problems with some of our judicial systems?
I absolutely do, and especially in Florida. Now, I live in Florida, as we all do, and in Florida, we have an interesting system that's really, I think, unique to the rest of the country, and it's called judicial retention. Judicial retention is this: a person is nominated by the governor to be on the Supreme Court, which has 7 members. The Senate confirms that person. Where does the governor get the names? Well, there is a judicial nominating commission that gives a list of names to the governor and says, pick from this list of names. Now, a former governor of Florida, Charlie Crist, decided he didn't like a list of names that he got. And he said to the Judicial Nominating Commission, give me another list of names. They said no, and the Florida Supreme Court sided with the Judicial Nominating Commission. So the governor really is expected to pick from those names. Once that person is confirmed, they serve in office for what we might think of as 7-year terms. But what it really is every 7 years, their name has to go before the voters. Do you want this person to stay in office or not? Yes or no. So you're really running against yourself. So if there are more no's than yeses, you're out of a job. If there are more yeses than no's, you stay, except, interestingly enough, Florida Supreme Court, this is Florida, has a mandatory retirement age of 70.
Wow.
Yeah. So of all states in the country, to have a mandatory retirement age that's really, quite youthful, right, considering our elderly population here is really kind of interesting. So you can't, so if your 7-year term, if the middle of it you turn 70 years old, then you have to go. So what some people argue is that because there's always that threat of a no, that there can be maybe some decisions made that might affect your possibilities for retention. Because certainly we've seen in Florida that interest groups might have sort of mounted campaigns that favor not retaining a justice.
Right. And I see that, yeah. And many times people don't pay close attention to the decisions made by the state Supreme Court anyway. I guess the closest was in 2000 with the state Supreme Court's decisions. Of course, that was repealed up to the U.S. Supreme Court with the election.
Yeah, you're talking about Bush versus Gore again?
Yes, indeed.
Yeah, hard
and
not
there you
to.
Go. And my thing is, we talked about the vagueness of the Supreme Court. How did they establish how did the Supreme Court, U.S. Supreme Court, establish itself as an equal partner, if you will, in the three branches of government?
That's a great question. You know, it's interesting because we've heard this term bandied about of judicial review. We know that when Supreme Court nominees are being asked about, should this be a law, should that be a law, really what it is that's getting at that power of judicial review. And if you don't read the U.S. Constitution, you would think that judicial review is in the Constitution. However, it's not. Judicial review, which is the right for the courts to say that a law violates the Constitution, was actually established by the U.S. Supreme Court in 1803 in a case called Marbury versus Madison. Marbury versus Madison was a case where the question before the court was, can the court be forced to compel someone to do something that the law says has to happen if it's violating the Constitution? The issue at hand was the Federal Judiciary Act said that the Supreme Court could be approached and asked to issue what was called a writ of mandamus, basically mandating that someone do something, that a government officer do something. Well, it turns out that the writ of mandamus was established when the Article 3 says there are certain cases that can come to us under original jurisdiction. All other cases come through the appeals process. Well, the writ of mandamus was saying use the courts for original jurisdiction. The Constitution said these situations can be original jurisdiction, writ of mandamus not being among them. So what the court ruled was that the Federal Judiciary Act, or parts of it, did violate the U.S. Constitution. Now, what gives them the right? Well, the legislature makes the laws. Who signs laws into laws but the executive? So who is not involved in the legislative process but that little weak, vague branch that
right.
sort of somebody threw in there, right? And that sort of keeps the integrity of separation of powers and checks and balances, because indeed, since the other two branches write the laws, the only ones who could decide that something violates, that an action of those two branches violates the Constitution would be the only team not involved, right, so to speak. So in many respects, that's how the Supreme Court gave itself the power of judicial review in the case of Marbury versus Madison, which involved an interpretation of a component of the Federal Judiciary Act. And so we now, as you say, and that's a really good point, the Constitution hasn't changed. We still have no set number of judges, no terms of office, no qualifications, but their power has enhanced quite a bit. Their power has grown, even though the Constitution itself hasn't changed, in order to accommodate what was supposed to be the weakest branch to now many people say is equal in power, because indeed, with a 9-person court, majority rules, 5 people can undo the work of the entire Congress.
Wow. Yeah.
Right? All 535 people can vote one way, 5 justices can vote the other way, and it's done.
Null and void.
John, unfortunately, we're done too. This conversation has to come to an end. We've been talking about levels, functions, and powers of the courts at the state and federal levels as established in the Constitution. That's Conversations in Civics. I'm Dr. Terry Susan Fine.